False allegations in family court sound familiar? Well, nobody warns you that the family court system can feel like walking into a room where the other person has already told their story and everyone in the room already believes it. Your ex has had months, maybe years, to build a narrative, and now you are standing there trying to explain something that most judges and evaluators may never have learned about in their training. Hi, I am Cathy Jo Hart. Our video today is not going to tell you that the system is fair because in some cases it isn't. But it is going to tell you what actually matters, what documentation does and does not do, how to read a custody evaluator, and how to give yourself the best possible chance of being seen clearly. Not because you deserve to win, because your child deserves the truth. Now, before we go any further, I need to say this clearly, and I will say it more than once. I am not an attorney. Nothing I share in this video is legal advice. Every state has different laws. Every case is different. What I am offering here is general information, the kind of preparation I wish someone had given me to help you understand what you are walking into. Please work with a qualified family law attorney, ideally one who understands parental alienation. Now, that is not optional. This is the fourth video in my Parental Alienation Awareness series. And so far, we have covered the research, the work of reconnection, the grief of healing, and now the legal landscape. Links to all the other videos, including the free resource guide, are in the description and comment sections. Let me provide some honest context before we get into what you can do, because understanding the terrain is part of being prepared. Parental alienation cases are uniquely difficult in family court, and the reason is straightforward. The evidence is psychological and behavioral, not physical. There are no bruises to photograph. There are no police reports. The harm is invisible, and it is often dismissed by professionals who simply have not been trained to recognize it. I want to share a piece of research that every targeted parent should know about. In 2020, Professor Joan Meier published a study funded by the U.S. Department of Justice. She analyzed over 4,000 custody cases, and what she found was this. When mothers alleged abuse and fathers cross-claimed parental alienation, courts were more than twice as likely to disbelieve the mother. And when alienation was credited by the court, mothers lost custody in 73% of the cases. I share that data not to discourage you, but to make sure you go in with clear eyes. This is the playing field. And when you understand it, you can prepare for it. Here's the other piece. Many judges and custody evaluators have not received formal training on parental alienation. You may find yourself in the position of educating the professionals who are supposed to evaluate your family. That may be frustrating, but that is reality. And the more organized, credible, and evidence-based your case, the more likely it is to be heard, even by someone learning about PA for the first time. Without documentation, PA cases almost always get reduced to he said, she said, competing narratives with no way to distinguish truth from manipulation. So the single most important thing you can do, starting right now, is document. Documentation is the foundation of everything. This is the most practical section of this video, and honestly, it may be the most important. If you take nothing else away from the next 15 minutes, take this. Your documentation is the foundation of your entire case. Your attorney can only work with what you give them. I am going to walk you through 5 categories of documentation. Now, if you are in the middle of this right now, I would encourage you to pause and take notes or come back to this section later. These are specific and actionable. Number 1, a communication log. Keep a running, dated log of every interaction related to the children. Missed pickups, refused phone calls, canceled visits, messages that disparage you. Anything the child says that echoes the alienating parent's narrative. Write down the date, the time, what was said or done, and who was present. Keep the language plain and factual, no emotion. Courts respond to patterns. 1 incident is an anecdote. 12 incidents over 6 months? Well, that is a pattern. And number 2, digital evidence. Screenshot everything. Every disparaging text. Every email that blocks access, every social media post that involves the children negatively. Make sure the date is visible and the context is clear. Now store everything in a cloud backup and a second location. A USB drive, a printed copy, something physical. Courts increasingly accept digital evidence. Now, one important note. Check with your attorney before recording any phone calls. Recording laws vary by state, and using a recording made illegally can actually hurt your case. Number 3, third-party witnesses. Teachers, coaches, therapists, pediatricians, neighbors, family, friends, people who have independently observed the child's behavior or the alienating parent's conduct. Ask them if they would be willing to write brief, dated, factual notes about what they have observed, and these can later become declarations or testimony. Third-party observations carry significant weight because they come from outside the conflict. Number 4, a behavioral journal for the child. Document observable changes in your child. Specific statements, word for word, dated. Behavioral changes before and after visits with the alienating parent. Refusals, anxiety episodes. Keep this clinical and observational, not interpretive. Write, on March 3rd, my daughter said, Dad says you don't really love us. Do not write, I could tell she had been coached. Let the evidence speak. The pattern will be clear. And number 5, your own positive parenting record. Now, this one gets overlooked constantly. Document your involvement, school events you attended, medical appointments, photos from activities, receipts, report cards you received. Build an affirmative record of who you are as a parent. Courts want to see both the problem and the solution. You as a present, engaged, and stable parent. And one last note on documentation. Organize it. Create a dedicated folder system, both digital and physical. Date every single entry. When you hand this to your attorney, it should tell a clear, chronological story. That organization alone communicates credibility. In this next section, our focus is custody evaluators. Custody evaluators can make or break a parental alienation case, and most targeted parents do not know what to look for until it is too late. So let me walk you through this. A custody evaluator is a mental health professional, usually a psychologist, appointed by the court or agreed upon by both parties. They interview both parents, the children, and collateral contacts like teachers and therapists. They may administer psychological testing, and then they produce a written report with custody recommendations. And here's what you need to know. Judges give that report enormous weight. It often drives the outcome. So when an evaluator is appointed, you need to ask, or have your attorney ask, some critical questions. What is their specific training and experience with parental alienation, not just high conflict custody cases, PA specifically? How many PA cases have they completed in the last few years? Do they understand the distinction between parental alienation and estrangement? As we have learned in previous videos, these are not the same thing. And are they familiar with the 5-factor model for PA assessment developed by Dr. William Burnett? Now, here are the red flags you need to pay close attention to during and after an evaluation. The evaluator spends significantly more time with the other parent than with you. Unequal interview time is a documented bias indicator. The report uses emotional or judgmental language about you, rather than neutral clinical terminology. The evaluator dismisses or minimizes your documented evidence without adequate explanation. Recommendations appear disconnected from the actual evidence presented. Or the evaluator pathologizes your concerns about PA without investigating them, essentially treating your awareness of the problem as evidence that you are the problem. If you identify bias in an evaluation, here is what you can do with your attorney's guidance, of course. Request that your attorney cross-examine the evaluator on their methodology and conclusions. Request a second evaluation. Now, this is expensive, but sometimes it is necessary. Have a PA knowledgeable expert review the evaluation and provide a written critique. Document every discrepancy between what you said in the interview and what appears in the report. Again, I am not an attorney. A rebuttal strategy requires legal guidance specific to your jurisdiction and your case. But knowing what to look for, well, that's preparation. And preparation is power. Now, here is something I wish someone had told me years ago. Many targeted parents walk into court making the wrong argument, not because they are wrong about what happened, but because they are framing it in a way that courts cannot use. Courts do not respond well to emotions. My ex is an evil person who is trying to destroy my relationship with my child. Even if that is true, and I know for some it is. That framing sounds like a war, and courts want stabilizing parents, not escalating ones. Courts do respond to specific, documented, behaviorally described patterns. On this date, the child missed the court-ordered visit. On this date, I received this message. On this date, the child repeated these specific phrases that mirror documented statements the other parent has made to me. Now, this is the most important advice I can give you. You must frame everything through the child's best interest, not the parent's behavior. The child's best interest standard is the primary lens in virtually every family court in the country. Frame everything through it, not my ex is alienating me, but this pattern of behavior is harming my child, and here is the documented evidence of that harm. And here is the other piece. Courts respond to parenting stability. Your ability to demonstrate that you are calm, consistent, non-escalating, and child-focused is every bit as important as documenting the other parent's behavior. You need to show both the problem and the solution. And one more thing. In many jurisdictions, the court can appoint a guardian ad litem, sometimes called a GAL, which is an attorney for the child. And this is someone whose sole job is to independently represent the child's interests. If you believe your child's voice is being suppressed or distorted by the alienating parent, request this through your attorney. It adds another set of eyes, and in PA cases, that can be critical. And finally, how to find the right legal team. Most family law attorneys do not specialize in parental alienation. Finding the right team matters enormously, and it starts with the right questions. When you are interviewing a prospective family law attorney, ask the following. Do you have experience with parental alienation cases specifically? How many in the last 3 years? And have you worked with PA specialized mental health experts as part of a legal team? And how do you approach cases where the other parent has made significant narrative gains before you were involved? And what is your strategy if a custody evaluator appears to be biased? Now, if they cannot answer those questions, or if they look at you blankly when you mention parental alienation, they are not the right attorney for this case. It doesn't mean they are bad lawyers. It just means this is not their expertise. And here are some resources for finding PA-informed legal professionals. The NAOPAS, the National Association of Parental Alienation Specialists. Their directory includes legal professionals. The PASG, the Parental Alienation Study Group, is an international research and professional network. Dr. Amy Baker. Now, Dr. Amy Baker's coaching service can help targeted parents prepare for attorney meetings and custody evaluations. State Bar Associations. Your State Bar Association's family law section often maintains specialist directories. You can download a PDF of this information listed in the comment section. Now, I want to be transparent about the cost because it is a real barrier. PA litigation is expensive. Custody evaluations alone can run $5,000 to $20,000. And legal fees in contested PA cases can reach into the tens of thousands. I know that number is staggering, and I am not going to pretend otherwise. For parents with limited resources, I have the following advice. There are legal aid organizations that exist in every state. There are pro bono family law clinics and law school family law clinics that can sometimes help. PASG and NAOPAS may have referral sources as well. Now, this fight is not supposed to be only for people who can afford it, but I want you to know the landscape honestly. Now, this section is for people like me, parents whose children are now adults. The court system is no longer relevant to your situation, and that is both a loss and a relief. The legal phase is over, but the harm is not. If you watched previous videos in the series, you know that adult alienated children can and do reconsider. The door is not closed, even if the courtroom is. What you can do in the absence of court is to document your truth for yourself in writing, not for litigation, but for your own clarity, and potentially for your children if they ever seek to understand what happened. Some targeted parents of adult children find it meaningful to write a factual, unemotional account of the family's history, not to send, but to have. Something that exists outside of the alienating parent's narrative, something that is yours. Because this is your story too, and you have the right to it. And this is what I did. I realized my story had been rewritten and reshaped to fit a narrative that simply did not exist, or one I simply did not recognize. There was no other way I could communicate my story without it being seen as defensive or that I was trying to avoid accountability. I found that writing acts as a powerful tool for emotional release, for cognitive processing, and for self-discovery. It offers a safe, private, and accessible way to manage stress and traumatic experiences. By putting complex thoughts and feelings into words, it helps people to organize, analyze, and make sense of their internal world, which helps reduce anxiety and improve mental health. So I encourage everyone who is watching this to write your own story because your story is very important. This is for you. You deserve to heal. Dedicate 15 to 20 minutes a day for a couple of weeks to write. Don't worry about how it sounds or how it reads. That is not the point of writing. You should have one goal, and that goal is to write your story for your healing. This is for you. As we end our show today, I want to thank you for joining me. We have covered a lot of ground together, from the research that proves this is real, to the honest work of reconnection, to the grief of healing, and now to navigating the legal system that was supposed to protect your child. The law is imperfect. The system is imperfect. Judges and evaluators are imperfect. But your love for your child and your decision to keep showing up, to document, to prepare, to grieve, to heal, to reach back out, that is not imperfect. And that is exactly what a good parent does. If this series has helped you feel less alone, share it. Someone else is sitting right now in the silence that you have been sitting in, and they need to know they are not the only one. I have also included free downloadable PDF guides in the comments section of this video. These are to help you with your healing and legal journeys. I have included a PA recovery guide, a positive parenting record, and a PA documentation guide to help parents navigate the complexities of parental alienation in family court. Please join me next time when I will be answering your questions about parental alienation and estrangements. Please leave me a comment letting me know where you are in your estrangement journey. Until next time, may the Lord continue to bless you on your journey. Amen.